Hello, Facebook. I am live with Jennifer James, Trust and Estate Attorney Extraordinaire. And she's going to talk to us a little bit about if we can sell a property without or keeping our tax basis as low as possible if we're over 55 or disabled. How are you today, Jennifer?
Good. Thank you for having me. It's a pleasure to be here and to talk to you about the changes in the tax laws.
Awesome. I'm so excited to have you. So Jennifer did my first trust and estate plan, I don't know. Let's see. Well, Roshan is 8. So I think we waited around until our second was one. So probably 7 years ago, you did the first one for us and have been amazing at helping us keep our trust and estate updated over the years. So thank you for all of your help with that. So I was excited to see this on the ballot this year because I do sometimes, get calls from people who bought their house 20, 25 years ago for $250,000. Now it's worth $2 million and they don't want to sell it because they can't afford to pay, the property taxes on a new home. So can you talk a little bit about what was Prop 60 before and what has now been replaced by Prop 19?
Yeah, definitely. So basically all of this started with Prop 13, which is the main landmark proposition that amended the California Constitution and dealt with real property taxes. And from there has been several propositions that have either expanded Prop 13 and either stated that property taxes were going to be set at a certain value, which Prop 13 basically did. It said, as of 1976, it was enacted in 78, but as of 1976, that's going to be your base year value, what the fair market value of the property was. And then from that point forward, it's purchase price if you purchased after 1978, and it could only be increased annually. And it's basically 1% of the value at that time, but could only be increased annually for inflation up to 2%. And so that's huge because, as we know, property values in California over the last 40 years have increased substantially. And so if we're going to limit the base value for property tax purposes from increasing more than 2% per year, some people that live in multi-million-dollar homes now that bought it for much less, obviously, are paying substantially lower property tax values. So in a neighborhood, you can have, one neighbor that bought the house 30 years ago at $300,000, paying $3,000 in taxes, property taxes per year, and then the next neighbor who bought a property just recently for $1 million is paying far higher in property taxes at $10,000 per year. And so that's substantially different based on the property tax values. And it was a huge benefit for those who purchased property at a much lower value to continue to pay property taxes at that rate. And now that properties have increased in value so much in California, obviously it's restricted some people from feeling that they can move to a new property because they can't purchase at a much higher price and then also pay the increase in property taxes when they're kind of locked in on such a lower rate that's affordable to them. And that causes some problems, I think, definitely just for people who are elderly. I hate how in the propositions they're saying 55 years old is the elderly, but people that are 55 years and older can move, and that was Prop 60, can move and transfer their property tax basis. Prop 60 was that was 1986 when it was first enacted, but could transfer their property tax basis once to another location in the same county of equal or lesser value. And so in that was huge because you could get rid of a larger home or a home with stairs or move closer to family or whatever it was that you wanted to do. The reason why you wanted to sell your house, you get to take your property tax basis with you. And that was huge for people.
But the hard thing is what about, you and I both have kids and they're young kids, but at some point, God forbid, they may decide to move far away and I will be following my children all around the world.
Yes.
Setting up shop right next to them.
Well, if it's in California, this proposition will help you. Anywhere in California now.
But it might not be, right? Like they might go to Wisconsin or, Iowa or, who knows? And so in that case, right, then, well, I guess in that case, I wouldn't care because I'd have low property taxes where I'm going.
That's
okay.
true.
All right. Throw that one. I'd be buying my $200,000 house and like calling it a day.
Right.
Okay. So it's really the new thing is that I can buy a more expensive house than I could buy before, which previously I could not. Correct?
Right. And that's also in any county in California, where previously they were limited to just 10 counties in California that were basically participating in this, which was difficult too, because many counties in the state of California didn't participate, and you couldn't just transfer your tax basis anywhere, which in places like that were hit with natural disasters, and if you didn't go outside of the county, if you were in the county, you couldn't move within the county and get a new property. So it's now anywhere in California, and they also increase the number of times that you can do it. So it was previously only one time where you could transfer your property tax basis, and now it's up to 3 times, and you can buy a lesser property or a more expensive property. So if you are moving to a location which may be in a more expensive area because your kids or other family or friends that are there, you can do that. You can transfer your property tax basis, but there is going to be an increase from what you are currently paying. You can't, buy a house that's worth $2 million more and not pay property tax on that
difference
in value, the difference. But certainly you can transfer the basis that you have over.
Got it. Well, I'm excited about that because I think it's going to mean more sales and, I mean, who wants to live in a house that's way too big for them or like you said, has stairs and that sort of thing. So I think that's fantastic. But I think there are some downsides to this for some families as well. Can you talk a little bit about what those are?
Yeah, so with the devil's always in the details, Prop 19 does have a lot of things that do benefit people, mostly people 55 and older. I'm not going to say elderly again, 55 and older, and people that have chronic disability and have suffered some sort of natural disaster. So that's the benefit, and we've talked about that. But the con is that in order to pay for these types of transfers and to support that, you're basically getting rid of something that a lot of families relied on, and that was the parent-child exclusion and parent-grandchild exclusion. So another thing, so people can't inherit property now at the same property tax basis that their parents were paying. And that was a huge benefit for people in California. I don't think any other states really have something similar, but this was ever since when that was first enacted was Prop 58 in 1986 was the parent-child exclusion. And basically, a child can inherit from their parents who inherited from grandparents who bought the house 40 years ago and had a property tax basis at a very low number because it was based at 1% of the value back then. And it's been just passed down from generation to generation, only increasing in value for inflation up to 2%. And that's huge because, again, going back to people in the same neighborhood paying very different levels of property tax. And the reason why I think that was enacted initially was that children could move into their parents' homes and not suffer what's called a change in ownership, where the property gets reassessed and then they have to pay property taxes that they can't afford.
So let me make sure I get this clear. So not only if I pass my house down to my children, not only would they have to pay the step up in property taxes when they sell, but they would actually have to pay it when they get it, which means in some cases they can't afford it and would need to sell it in order to pay the taxes. Is that right?
And sell immediately too, because if the property tax was low, I mean, if the very low and the property has increased in value substantially, the change in ownership happens as of date of death. So, it takes a while to prep the property for sale and then go on the market. All of those months, even though it's going to be sold, are going to be reassessed for property taxes at the new fair market value. And so that's what changed with Prop 19, is not only did it get rid of that, which ultimately we had more than just the primary residence that we were able to do under Prop 58. You were allowed to transfer any amount of in your primary residence. So your primary residence could be worth $6 million. It didn't really matter, $8 million, $10 million. You could transfer that to your kids. And then additionally, each parent could transfer $1 million in assessed value. So it applied to commercial buildings, rental properties, investment properties, vacation homes. And so ultimately, if you're talking about assessed value, you could pass multiple properties, because the assessed values on those might be 200,000 each. So 200,000, 5 different investment properties that were going to the kids where they maintain the property tax basis. So it's huge. And the change is now that this is only going to apply to primary residents, and it's $1 million of fair market value. So you get your assessed value plus the $1 million, and then everything else gets reassessed. And if a property's worth $6 million, $4 million. I mean, we do live in California. Property values are high here. The kids are going to have substantially more to pay in property tax than they did before.
Got it. And then I'm guessing there's maybe some loopholes or some things that people can do now before April 1st or in order to help with all of this.
So actually there's 2 different effective dates. So for the Prop 19, 55 and older, and moving your property tax basis or taking your property tax basis with you, that's effective April 1st. The reason why estate planning attorneys are so busy right now is because the parent to child exclusion, where that's being removed, is effective February 16th, 2021. And the 15th is a holiday. And so ultimately we're going to have to get it all done within the first couple weeks of February and before, obviously, because we need appraisals. But ultimately there are clients who are calling and trying to make transfers to their children now. Now, the problem with that is that you have to weigh a couple things, because if you gift property to your kids while you might be retaining the parent to child exclusion for property taxes, you lose the step up in basis that they would receive if they inherited the property upon your death, which can be huge if the basis in the property is low, and then the kids would have to pay substantial capital gains tax if they ever sold the property. So this is only...
Okay, hold on, rewind. I bet you a lot of people don't know what step up in basis means. So can you talk to me like, I'm an idiot?
Yes, so everybody has a basis in most assets. Your basis in your home is your purchase price, and that might increase or be adjusted for improvements, etc. But the basis is the purchase price. So let's just start there. If your parents bought the property many, many years ago, and then they gift it to you during life, you take their basis. We call it a carryover basis. So if they bought it at 200,000 and it's now worth $2 million, we have substantial gain on that sale if it sells at the $2 million. That would be taxed at long-term capital gains. But if you inherit the property, which is another way that people pass wealth to their kids, if you inherit the property, then the kids inherit it at a step up in basis on death. So then if they sell the property, they have no capital gains tax. So it really depends on every single family situation. It needs to be looked at closely as to what you're going to do, and if you're going to do anything before the February 16th deadline, because a lot of families don't have the ability to just gift real estate to their kids. Some families do. And if they do have that ability, you're going to be looking at everything. You're going to be looking at their overall estate, their taxable estate, whether the kids even want to keep the property. Maybe they're living on the East Coast or somewhere else where they're not going to keep the property and rent it. And so the property tax value doesn't matter. They don't want to have it gifted at a lower basis, because they're going to have the carryover basis. They'd rather just inherit it and sell it with no capital gains, because the property taxes won't matter. They're not going to continue to pay them. So you really do have to look at every particular situation. There are ways around it. I know a lot of estate planning attorneys are talking about not only lifetime gifts outright to their kids, but lifetime gifts into trusts for the benefit of their kids, taking advantage of some advanced estate planning tools potentially creating LLCs where you can transfer portions of the interest in the LLC to the kids. You have to, it's kind of like a step transaction, but ultimately you transfer it and then you create an LLC. And as long as the ownership interest when you create the LLC are the same as they were prior to transferring the property into the LLC, then it doesn't get reassessed again. So there's specific laws around that. And I just think if anybody's considering or is concerned about the potential negatives of Prop 19, being that the parent-child exclusion is basically going away, except for in limited circumstances, then I think they need to talk to their advisors.
Got it. Got it. Okay, so is that everything on Prop 19 before we jump into like maybe a couple of questions about changes in presidency and potential tax things that might be coming up?
Sure. Happy to talk about that.
Okay. Yeah. Just curious. I know there's been a lot of talk around, Biden's going to make some changes and stuff like that that's going to affect taxes. And so anything that people can be thinking about now with regard to their estate before changes take effect that could help them.
Yeah, so there is still a little bit of uncertainty. We do know that Biden has, well, let's be careful about how we say it, but we know that right now Biden's won the election. And the Senate, there's still some outstanding on who's going to control the Senate. If Republicans remain in control, some of these things may not be so imminent. But he has proposed in his tax plan a reduction in estate tax exemption amount. So it's currently 11.58 million per individual, which is relatively high. And if you look back on what the estate tax exemptions have been over time, it is currently increasing every year for inflation. So it'll be 11.7 in 2021, and it's scheduled under current law to revert back to what it was in 2012, set at 5 million increase for inflation in 2026. So as of January 1st, 2026, we already have kind of a reversion back to the 5 million increase for inflation. But Biden has proposed to reduce it to 3.5 million per person and potentially increase the estate tax rate, and also get rid of that step up in basis that we were just talking about. So a lot of things are still up in the air. I think it's probably more likely that there will be a reduction in estate tax and potentially increase in the rate of estate tax. I think it will be a little bit more difficult to get rid of the step up in basis, but nobody has a crystal ball. We're all kind of just waiting and seeing and doing the best we can with the information that we know. Now, for my clients that do have taxable estates already or already close to taxable estates, we are talking about making gifts, right? And it can be gifts of any type of asset to try and remove assets outside of the estate for estate tax purposes. So there's always ways, and your estate planning attorney can help you with that. There are advanced planning tools to gift assets out of your estate and maintain a little bit of control or some benefits of those assets, but pass the assets to your children in what we call generation skipping trusts, but basically allowing them to inherit assets that won't be included in their estate for estate tax purposes, because those generation skipping trusts are sometimes referred to dynasty or legacy trusts. We don't want the assets that pass to every generation to be subject to tax at every generation. So if parents pass their exemption amount, they can pass it to their children and their children can use it, but as long as they don't take the money out of the trust, it will stay in trust and then it can pass to their children without being taxed at their death. So there are some advanced tools, things to think about, knowing the estate tax exemption amount. Do we want to make any lifetime gifts, any charitable planning? We don't know exactly what's going to happen, but I do think there will be time to make a lot of these lifetime gifts. It's interesting. While I thought that a lot of clients would be calling me for lifetime gifts related to the exemption amount, I'm getting more calls on the Prop 19 changes, not only from people who want to take their assessed value with them because they meet one of those three categories, but also from parents who want their children to inherit the property and keep it and maintain the same property tax basis.
Awesome. Any other questions? I'm sure your phone is ringing off the hook, so thanks for taking the time to do this. Any other questions that you keep hearing over and over again from people?
Mostly it is about Prop 19 and what it is that what they're required to do, what are they taking with them. So the one call that I got was from a client, a potential client, who basically said, well, will I be taking my basis in property tax from when I first purchased the home, or the adjusted basis as increased for inflation? Which I thought was relatively clear from the law, but ultimately you're taking your adjusted basis, what it is as of today's date, to the new property. And then the other questions that a lot of people are asking with Prop 19 is there is a requirement for the child to maintain the property tax basis, that $1 million and assessed value and property tax basis. There's a requirement that the child move into the primary residence and make it their own primary residence. And what does that in fact mean? Unfortunately, the BOE, the Board of Equalization, has not made all the rules public yet. They're revising the assessor handbook. They weren't the ones that proposed this law, so I don't know if they're really happy about the fact of how quickly they have to revise the assessor handbook. But in any event, we're all still kind of learning, but normally what primary residence means is that you're taking a homeowner's exemption on your property tax bill. So you check that little box, and not everybody does it. So if you haven't done it, make sure you check that box, even though it's only, $70 off your property tax bill. It is making an affirmative statement that this is your primary residence.
Yeah, got it. So Jennifer, if people have more questions, which I'm sure they will, what's the best way for them to get in touch with you?
I'm happy to answer any questions that people have. My email is great, but where you can find all my contact information is on my website, which is just www.jenniferjanes.com, and Janes is Jay, N as in Nancy, ES.
And I'll put it in the transcript and the chat as well. Thank you so much for taking your time whenever things are so busy for you to do this for us today. I really appreciate it, and I learned a lot.
I'm happy to be here. Thank you so much, Ruth, for giving me the opportunity, and I look forward to talking to you soon.